Hello students, I'm Dr. L.K. Das, Assistant Professor of Sociology at the Department of HSS, IIT Roorkee. Welcome to another lecture of the NPTEL course Power and Politics in Contemporary India, a Sociological View. In this lecture, we'll discuss about the rights. All of us understand that the Constitution of India has given us something called the fundamental rights, in which one of the fundamental aspects of these fundamental rights are right to life. Now, within the paraphernalia of these constitutional rights, we have moral, legal and political vocabularies, which citizens of India and citizens of any other country who have their own constitutions can articulate their grievances. They can challenge authority and they can also seek justice by different means. It could be through electoral processes, it could be through non-electoral processes in the form of visiting the courts of law. Now, in today's lecture, we'll specifically focus on judiciary and will specifically focus on politics, the way it is being played out at the level of courts of law, at the level of what Upendra Baxi calls as politics of judicial power. Now, the theoretical foundations of rights and mobilization lies in the constitutional regime, in which there are legal claims to challenge injustice, assert identity or demand state accountability, particularly when political institutions appear unresponsive or morally compromised. So what does this mean? It means that you are happily sleeping or sitting on your couch in your drawing room and watching news channel or watching something on TV. All of a sudden, there's a knock on your door. There's somebody, you go open the door, there's somebody standing there wearing a uniform. And these men and women in uniform, they drag you out of your house, put you in a vehicle and then take you to either to an unknown or unidentifiable location or to a police station. You don't know what happened. But as a citizen of this country, it is your legal right to know why you have been picked up, or why you have been detained, or why you have been arrested. Now, in each one of these cases, the people, if they are police force or if they are in police service or if they are in something else, they have to give you a justification as to why you have been detained or why you have been arrested. And they have to give this justification because the Constitution of India gives you the legal right to know what are your rights. And if you feel aggrieved, either you can directly approach the political connections. But what if you belong to an opposition party and you have no political connections as such? Then the next resort is that you file a case against the state of India or against that particular provincial state and say that in the court of law, claim that your right as a citizen of this country, your fundamental right to life has been violated. So this is where the idea of rights comes into picture, because the Constitution of India or the democratic Constitution of India not only gives you rights as a citizen, but also tells you or gives you the right to question the state itself, because the state is not above any citizen. The state of India is constitutive of the pillars, that is, we the people. That is the reason why the Constitution of India starts with the phrase we the people of this country. So Indian state is and its agencies are not superior to the citizens of this country. But as we discussed it in the previous class, particularly when we discussed about Durkheim, this Indian state functions under the obligation of certain moral social consciousness. And when we're talking about moral social consciousness, that means we are talking about certain kind of rights and certain kind of mobilization mechanisms. Now, rights, as an example that I gave you, is about your right to life. But what if this individual happens to be a political activist, and this individual has been fighting against a particular state or the Union of India so that at a given place a dam is not constructed or people are not dispossessed. That means this is not just any detention or any arrest, but this is a way to marginalize certain voices coming from the margins. So the role of the law here is to listen to all the people, or we the people, who are standing in support of the marginal voices, so that the rights are not violated. So that is the reason why mobilization is also about political organizing and mass mobilization for deliberate political engagement. Hirschl discusses that this is a deeply problematic situation. It is a deeply problematic situation because now we are not a democracy. So the demos has given a certain amount or a greater amount of its the moral right to the jurisdiction forces. That is the reason why he is calling it juristocracy, the rule by the judges. And the rule by the judges means that the way politics as such functions, or the way democratic politics as such functions, it is threatened. Now everything is being decided by an unelected the judiciary, and this judiciary is taking the role of the state. So the supremacy of judiciary can also mean risking deliberative politics and substituting public dialogue with legal formalism, precedent and expert reasoning. Now, as we discussed previously, it could also lead to only certain kind of people getting justice and many other kind of people not even able to reach those positions. So there's a reason why millions of cases are pending in the Indian context or in India, whereas people with power, people with reach can get a suitable verdict even at 12 o'clock in the night. So this is where, according to Hirschl, we are witnessing a certain form of juristocracy. Pratap Bhanu Mehta, on the other hand, argues that the very reason Indian judiciary has attained this moral authority is because the population or the citizens of India look at judges, look at the Indian judiciary as people with moral authority, as people with moral integrity as well as constitutional integrity at a time when there is moral decline of political institutions. We don't trust our MLAs, we don't trust our MPs, we don't trust our party leaders. Rather, we trust that the only place where people are not corrupt are in the Supreme Court of India or are in the High Court of India. So that is another reason why there is a this is a moral reliance, because of which Supreme Court India has attained almost a quasi-sovereign role. It can interpret the constitution, it can interpret any kind of law, it can nullify a law that is passed by state legislatures, that is passed by the Parliament of India, because it has now become the guardian of the Constitution of India or the Republic of India. Now this is a very significant position, and this is a very powerful position. So like the pop culture dialogue goes, with great power comes great responsibility. And now, as we have discussed here, do we see the great responsibility that is being taken care of in a position or in a situation of juristocracy? We'll come to it in a little moment. Upendra Baxi happens to be one of the most critical scholars here, because he's not a lawyer, but he has been writing about law since several decades. And he looks at law and the practice of judicial power in terms of history, how history repeats itself, or how the courts of law became people's court, particularly in the post-emergency period. The reason being that during emergency, the courts in India had surrendered to the Prime Minister of India. And because they had surrendered to the Prime Minister of India and her whims and wishes, so in the post-emergency period, many judges try to do something called judicial innovations and try to bring in public interest or encourage public interest litigations. I will not go in greater detail into this, because in the 50th lecture of this course, or at the end of this week, I have a very specific case study in which I'll discuss more about the PILs and the relationship between state, society, PIL, the relationship between Supreme Court of India, High Court of a particular state, and different kind of mobilizations, and how they impact each other in terms of decision making. So in other words, the Baxi says that while during the period of 2 years of emergency, the judiciary completely got subverted to the executive. In the post-emergency period, and with the formation of these people's courts, more and more people started believing and trusting the judges and the judiciary over the politicians. And here lies the moral and political stakes, because now somebody is speaking about rights-centered judicial politics. Now, right-centered judicial politics also means that whatever was happening on the streets is now happening within the scope of the court. And when something, which is the term that is used here, when something is sub judice, that means when a particular case is being discussed in a court, you cannot critique it. And if the court wants, it can bring at the intermediary the verdict or pronouncement, in which it can say that nothing that is discussed inside the court can be reported. So this is a way through which politics from off the ground, politics of the street, is being taken care of by politics within the closed environment of a court. And these courts, these judges, as I have just said, are non-elected, and most often than not, particularly in the case of Supreme Court of India, they come from particular families. So when it is happening in such a manner, then particular families, particular caste, particular class, and particular gender decides how this country is being run while calling themselves the guardians. So this is where the PIL lies. So public interest litigations, they mostly look at several issues, including as they started with bonded labor, environmental degradation, prisoners' right, so on and so forth. But they could also be used in order for rights-based mobilization. And right-based mobilization here means that bonded labor as a system was not insignificant. But because there was mobilization on the streets, that is the reason why through the court verdicts, bonded labor was abolished. Environmental degradation, somewhere somebody is feeling aggrieved because of what is being done, they go and file the PIL in the Supreme Court of India or in the or in any constitutional court. A constitutional court like the Supreme Court of India or High Courts of India, they interpret the constitution and they can take a call whether through this environmental degradation, dignity, livelihood and human treatment is being violated, or is it violating Article 21 of the Constitution of India, which prescribes or speaks about fundamental rights. Bhuwania has a problem with the way judicial populism and judicial populism has shifted from social action litigation or PIL to powerful mechanisms enabling courts to govern cities, regulate institutions and influence executive functions. In other words, they are looking at policy making. They're looking at how policies are being framed. They're looking at why policies are being framed. They're looking at the day-to-day activities of the executive as well as the parliament and the assemblies. So that way, the judges of these courts have a disproportionate amount of power, and because of this power, now they are interfering in the way the country is being run. Now, as I said, they are not elected members. They are not accountable to anybody except the Constitution of India, but they are not accountable to we the people of India. So when they start micromanaging governance, that means the question that arises here is that are they functioning within the guardrails of Indian democracy, or they are creating a certain kind of democracy for themselves in which they are the ones who are not now going to write or rewrite the Constitution of India through their own verdicts, through their own interpretations. Rights-based movements could move to different trajectories. One of the positive aspects of this is that right-based mobilizations remain central to the environmental protection, Dalit dignity, Adivasi autonomy, labor rights and gender justice across India. And what movements do is that they combine litigation with grassroots organizing. One of the Norwegian scholars, Kenneth Bo Nielsen, he suggests that, or he coins it by arguing that law and ladai, and he's speaking in the context of Singur and Nandigram movement that happened in West Bengal. Law means litigation, ladai means grassroots organizing. In other words, what law and ladai essentially means is that the rights-based mobilization or the groups who are participating in this, they're not just dependent on litigation or not just dependent on grassroots mobilization, because they understand that courts can move either ways. And many a times when it comes to the issue of development, courts, particularly in the post 1990 period, have given positive verdicts in favor of the state, or in favor of the corporate houses, or in favor of anything that relates to development. And this development could be at its broadest sense, but mostly it is about economic development. So grassroots organizing is a way even to pressurize litigation, and litigation is a way to pressurize grassroots organizing. So this becomes a cycle in which these groups are the shopping on different fronts, and when they are shopping at different fronts, that means they are highly aware of what could happen. So even if the judges of the Supreme Court or High Courts of India, they decide that they are now moving towards a judiciocracy, people who are working on the ground, they understand what are the drawbacks of it. So they not only move against the state on certain issues, they also move against the courts and its verdicts themselves when the rights get violated. So that is the reason why rights-based movements reveal how legal and political struggles mutually shape each other within India's democratic arena. So judicial politics, now if we call something as judicial politics, that means we are bringing two significant aspects together. One aspect is that judiciary functions according to precedents, according to legal codes. Politics works according to morality. Now, while PILs or judiciocracy at a face value speaks about empowerment of the marginalized, empowerment of certain sections of people, but there are scholars, there are legal luminaries who would argue that this is about judicial overreach, because the guardianship could oscillate, or the courts could oscillate between guardianship and domination. So that is the reason why there is an inherent tension when it comes to rights-based judicial politics. And this rights-based judicial politics could mean that judicial authority could rely on coercive powers, including something called contempt jurisdiction, which enables courts to command compliance without negotiation or deliberation. So you might have heard several anecdotes in which the judge of a particular even lower division court was traveling by a train. Something happened to him, he felt aggrieved, so he stopped the train at a particular railway station and hold his court there itself. Now this is an enormous amount of power or enormous amount of coercive power. Or the judges, they have given a particular verdict, there is a lot of criticism of this verdict, and because they do not like this criticism, so they say that anything that is being said about the judges or the court is a contempt of court. Because this is a contempt of the court, so anybody who utters anything will either be penalized through certain monetary penalization or through the imprisonment. This way, the role of empowerment could move to overreach, and there is a fine line between the two. So Nandini Sundar, through her ethnographic works as well as through the historical sociology works, has looked at some of the rights-based mobilization among Adivasis in Bastar and other areas. And she looks at the way legal redress without broader structural and democratic transformation could only lead to the same procedural processes that have been happening since the colonial period, and that has continued in the post-colonial period. So that is the reason why sometimes as citizens, the legal courts come to the rescue of Adivasis and others, but at the same time, through the verdicts of constitutional courts, the same Adivasis confront life-threatening challenges. Because of that, they are evacuated, they are evicted without further notice, without further recourse to these notices. So, what is the future of rights-based mobilization? So, rights-based mobilization depends on reconciling judicial intervention with participatory democratic politics, ensuring courts complement rather than replace collective political action, which means that rights as enshrined in the Constitution of India, they will always remain foundational and courts will always remain arbiters of it. But citizens have the role to see that neither branch of the state, whether it is executive, judiciary or legislature, they overreach or they take or they collaborate with each other in order to take away the rights as well as the political agency that citizens of this country have through the Constitution of India. Because as I said before, the courts of law have the authority to reinterpret or misinterpret the Constitution itself without rewriting what is mentioned there, without any form of recourse to its own judgments and its verdicts. So, within democracy, judicial power is important, but when it gets together with rights-based mobilization, it invariably expands democratic possibilities. So, in other words, rights-based mobilization deepens democracy rather than displacing it. So, the judicial power is still subservient to the democratic ethos of citizens of this country. But at the same time, judicial politics reflects broader crisis of democratic legitimacy, because when citizens of a country, they are not confident of the legitimacy of the state or its political representatives, that is the position when they keep moving to the judges, to the High Court or Supreme Court of India. So, we have a few discussion questions in which this is one interesting question: how do caste, class and Adivasi contexts reshape meanings of citizenship and the rule of law? And what would a democratic and socially grounded future for rights-based mobilization look like? So, these are the few references that I have used here. You can also read them. Thank you.